How does the Confrontation Clause relate to hearsay evidence? Imagine sitting in a courtroom and a key witness is missing. The judge faces a tough question. Can the evidence from that witness be used? This is where the Confrontation Clause comes into play. It is part of the Sixth Amendment, which guarantees a defendant the right to face the witnesses against them. This right is especially important when it comes to testimonial statements made outside the courtroom. Hearsay is a common type of evidence in trials. It involves statements made by someone who is not in court, offered to prove what they said is true. Usually, hearsay is not allowed because it's not tested through cross-examination. But if the hearsay is testimonial, the Confrontation Clause steps in to limit its use. Testimonial hearsay includes statements made to police, in affidavits, or during formal investigations. These are statements made with the expectation they will be used in a criminal case. The law says these cannot be admitted unless the witness who made the statement is unavailable and the defendant had a chance to cross-examine them beforehand. Non-testimonial hearsay, on the other hand, is not protected by the Confrontation Clause. It might still be excluded for other reasons, but the key point is that only testimonial hearsay is restricted. To decide if a statement is testimonial, courts look at its main purpose. If it was made to prove past facts for use in court, it is considered testimonial. This idea comes from Old English law, which believed face-to-face testimony and cross-examination were essential for truth. Modern courts have clarified that testimonial hearsay without the chance for cross-examination violates the Sixth Amendment. For example, forensic reports or statements from witnesses who are not present in court are scrutinized to see if they are testimonial. In real courtrooms, prosecutors cannot rely on testimonial hearsay from witnesses who are not available unless they have been given a chance to cross-examine those witnesses first. This rule helps protect defendants from being convicted solely on untested statements. It keeps the process fair and balanced. So, in simple terms, the Confrontation Clause limits the use of certain hearsay evidence in criminal trials. It makes sure defendants can face and question the people who made the statements against them. This rule helps keep the trial process honest and fair for everyone involved.